Very good morning to all of you. Here we will start Judiciary in India 3. We had already 2 sets on Judiciary and we have discussed very important questions, previous year questions related to Judiciary. We are inventing possible questions for upcoming examinations. So we are developing various type of new appropriate questions which are possible in the upcoming examinations. So this is Judiciary 3 overall questions we'll discuss. Okay, so most of the judicial questions are based upon Supreme Court, High Court and other things, but in this question set we have brought some questions related to the internal structure of the court and also related to PIL and other things. Public interest litigation, judicial activism, judicial review, these are all very important aspects of Indian judiciary. Okay, so in this section we will discuss some commonest of common questions including certain previous year ones. Should we start Judiciary 3? Let us start the questions directly. Question number 1. Which of the following statements about judiciary is false? Judiciary is false. Every law passed by Parliament needs approval of the Supreme Court. Do you think so? No, because there is no judicial supremacy. There is such kind of thing does not happen in separation of power. Democracy is based upon separation of power, so Parliament is independent. Every law does not need the approval. No law needs the approval of the Supreme Court. But yes, the law passed by Parliament can be reviewed, and if they contravenes Constitution or constitutional morality, then the Supreme Court may declare the act ultra vires. That will happen. So that means no law requires the approval of the Supreme Court. No law requires the approval of the Supreme Court, because it will violate separation of power. There is constitutional supremacy. There is neither judicial supremacy nor legislative supremacy. There is constitutional supremacy. So every organ of the government is independent of each other. No one requires to be approved by the other. But the constitution or constitutional morality and principles should remain intact. That's why the court can examine or review the constitutionality of an act passed by the Parliament. That is a different thing. So that is not correct. Statement 1 is not correct. As I told you the reason. Then statement B, judiciary can strike down a law if it goes against the spirit of the Constitution, that I was telling you. Just telling you about this. It is called judicial review. It is a unique power of the Supreme Court. Why it is laid down? It is laid down to restore to establish constitutional supremacy. Constitution is supreme. No other organ is supreme or as supreme as the Constitution. Next, statement C, judiciary is independent of the executive, obviously, because it is based upon the separation of power. Separation of power is the cardinal principle of democracy. So that is correct. Then any citizen can approach the court if his or her rights are violated. The right code are violated. Okay. So that is B, C, D are correct. A is incorrect. A is incorrect. Question number 1. A is incorrect. So answer is A. Okay. When the Chief Justice of a High Court acts in an administrative capacity, he is subject. Administrative capacity means superintendence, power of superintendence over all courts in the state, subordinate courts, except military courts or any other court that is made by the parliament. So that is mentioned in 2 to 7, Article 2 to 7, administrative power. Article 2 to 7 has a power of superintendence over all courts in the state except military courts and others. Okay. What does it mean? When the Chief Justice acts, he is subject to. He is subject to what? That means that is not a plenary power or absolute power of the Chief Justice of the High Court. He has to read jurisdiction of any other judges of the High Court. There is no meaning. Special control of exercise by Chief Justice of India, no. Discretionary power of the governor. So the power of the Chief Justice of the High Court of superintendence over all courts is subject to discretion of the governor of the state. That needs approval of the governor. Any law made by the High Court for the control or superintendence of the subordinate courts requires prior approval of the governor, and it must be in conformity with the existing laws of the state. That means the administrative power of the High Court over subordinate courts is not absolute in nature. So that is 2 to 7, clause 3 says that any provision made by the Chief Justice of the High Court with regards to the superintendence of subordinate courts must be in conformity with the existing laws in the state and must get prior approval of the governor. That is answer C, therefore. Answer option D, special powers provided to the Chief Minister in this regard, no. So C. It is Article 2 to 7. Consider the following statements. The Constitution provides for the procedure established by law. Yes, Article 21 mentions that. Procedure established by law borrowed from the Japanese Constitution. That the Supreme Court in Maneka Gandhi case versus Union of India 1978 interpreted Article 21 to include expression due process of law. Due process of law is the basis of judicial review in the United States of America. In India, the judicial review is carried on the principle of procedure established by law. It means the courts in India, especially the Supreme Court and High Court, can establish constitutionality and ensure that laws made by the parliament or state legislature and orders passed by the central and state government or any administrative action must not violate the constitution, must not violate the fundamental rights. That means that they are limited. If they do not violate the constitution, then they will be intact, they will remain in force. But in America, apart from establishing constitutionality, the court can examine the justness, fairness and reasonableness of the law. That is means a more wider, it is wider. The judicial review in America is wider than that of India. But in Maneka Gandhi case and later in many cases, the Supreme Court has been resorting to the American concept of due process of law. That means it also ensures, apart from ensuring the constitutionality of a law, order or action, it also ensures that such law, order or action is just, fair and reasonable. It's just, fair and reasonable. So that is a kind of things that are just, fair and reasonable. So both of them are correct. It is also correct. It is also correct. 3. Question number 3. Both 1 and 2 are correct. Let us see the option both 1 and 2. See. See, both 1 and 2. According to the Constitution of India, the term district judge shall not include. District judge includes chief presidency magistrate, session judge, tribunal judge are not included under the definition of district judge. Article 233 and 233 deals with the appointment of the district judges, and okay, so that does not include the tribunal judge. That does not include the tribunal judge. C4. Okay. Consider the following statements. The highest criminal court of the district is the court of district and session judge. Yes. The district judge is appointed by the governor in consultation with the high court. Yes. Appointed by the governor only in consultation with the high courts. Under Article 233, a person to be eligible for appointment as district judge should be an advocate or pleader for 7 years right standing or more, an officer in judicial service of the union and states. An officer in judicial service should not have been in the office. They should have terminated the office, but should be might have been an officer in judicial service of the union and states. That means should not have been in judicial service at the time of appointment, but before that it should be an judicial service. So that is correct. 3. When the session judge awards death sentence, it must be confirmed by the high courts. Yes. So that the power to award death sentence or capital punishment lies with the district courts, but they can do so only with the previous confirmation by the high court concerned. So that is correct. So all the statements in this question are correct. All the statements. Question number 5, all the statements are correct. All of these are correct. Got it? All of these are correct. Next, a person who, sometimes a previous year ones. Most of these questions are previous year one. Just I have deleted the year. 6. A person who has held office, not hold office, held office as a permanent judge of the High Court cannot plead or act any court or before any authority in India except the Supreme Court. A person who has held as a permanent judge of the High Court. There are different judges, permanent judges. Okay, the permanent judges are the part of the High Courts. There are also additional judges, acting judges. A person who has served as permanent judge of the High Court can practice in other High Courts and Supreme Courts. In other High Courts means other High Courts than the High Court in which from which he retires. So that means he can practice in other High Courts and the Supreme Court. But the statement says that cannot plead or act in any court or before any authority in India except the Supreme Court. No, that statement is incorrect. 7th Constitutional Amendment Act provided this, that a High Court judge can take up practice in any other High Courts from other high courts, from the last high court where he served. Okay, and also can take up practice in Supreme Court. So this statement is incorrect. This is incorrect statements. Statement 1 is incorrect. Now statement 2, a person is not qualified for appointment as a judge of High Court in India unless he has for at least 5 years held a judicial office in territory of India. Is not qualified for appointment as a judge unless he has at least for 10 years hold a judicial office in the territory of India. 10 years, it is 5 years, so the statement is incorrect. So both the statements are incorrect. Neither one nor two. Neither one nor two. D. We'll come to next question. These are very important questions and concept clear questions. Following these questions, you will develop a idea about understanding the core principle of judiciary, core provisions, and you can have a command over the chapter, isn't it? They're internal, very internal related or very based upon the basics of judiciary, which we need to understand. D is the answer. D is the answer. In which of the following cases the Supreme Court held that amending power and legislative power of the Parliament are the same, and a constitutional amendment act is also a law under the definition of Article 13? That was mentioned, that was declared in the Goloknath case 1967. The Supreme Court held that Parliament cannot take away fundamental rights by way of constitutional amendment, because a constitutional amendment act is also same as ordinary act, so that they are same, so they come under the definition of Article 13. And what does Article 13 says? Article 13 says that any law that contravenes the fundamental rights shall be void. So here Goloknath case is very important. Goloknath case 1967, that is related to this constitutionality, constitutional law, and other laws are important in this regard, are same. 1967. So question number 7, answer is B. Question number 7, answer is B. Next, who among the following has not been Chief Justice of India? Kindly look at the list of Chief Justice. We have had 50 Chief Justices so far. So kindly go through the list and examine and ensure that you remember how many Chief Justices were there, and who is the longest serving CJI, and who have been the Chief Justice of India since 1950. S.P. Barucha was the Chief Justice, B.N. Kripal was the Chief Justice, M.M. Madan Mohan Punchi, he was also the an eminent Chief Justice, and he also headed the second Center State Relation Commission. M.M. Punchi Commission is very popular, 2007 to 10. He headed the committee. Center State and made valuable recommendations. So G.S. Pathak was not the Chief Justice of India. He served as the Vice President of India. So the answer is D. Answer is D. D. So that is answer D. A separate High Court for Telangana came into existence on 1st January 2019. Here means the Hyderabad court or the court located in Hyderabad goes to the Telangana, newly formed state Telangana. It was restructured, so therefore the question is that. But remember, the High Court of Telangana is located in Hyderabad, the oldest court, one of the courts that was existent, and that was restructured and came into a new form on 1st January 2019. Okay, that is the things. The 19 and 9, question number 9, answer A. And number 10, which of the following is the correct chronological order of the high courts in India? We have discussed similar type of question in the last few sessions on judiciary. This is also for your revision, that there are 4 high courts are given, and their chronological order means year of establishment. Bombay High Court was established, is the one of the oldest high courts in India. It was established in 1862. Odisha High Court was established in 1948. Sikkim High Court was established in 1975, and Tripura High Court was established in 2013. So it is 1, 2, 3, 4. Kindly go through the list of high courts and keep abreast of the year of establishment and their benches, okay, for your examination point of view. That is Bombay, 1, 2, 3, 4. Today's question number 10, answer is A. Correct chronological order. Which of the following high courts headquarters is not located in the state capital? You will see some high courts have their headquarters in state capital, but some high courts do not have their headquarters in state capital. That is different things. For example, in Odisha, the headquarters of Odisha High Court is located in Cuttack, which is not the capital of Odisha. So there are a lot of states. So Madras, not located in the state capital. Madras is not located in the state capital. Acha, okay. So means Madras High Courts located in Chennai means state capital. Manipur is in Imphal, state capital, and Karnataka in Bengaluru in state capital, Rajasthan in Jodhpur. So that is not the state capital of Rajasthan. So headquarters is located High Court, Rajasthan High Court headquarters is located in Jodhpur. Although it has a bench in Jaipur, but its headquarters is in Jodhpur. So Rajasthan is the answer, D. All the 3 high courts have their headquarters in the state capital, as I have told you. Okay, it is question number 11. Now we come to question number 12. Look at the question number 12. Which of the following is not correct regarding appointment of judges of High Court? Appointment of judges of High Court is a constitutional provision. Is a constitutional provision. Okay. They are appointed by the president. Yes, they are appointed by the president. They are appointed by the president. And number 2, option B, The President consults the governor of the state. Yes, although he consults the collegium system, but he also consults the governor of the state while appointing. So the Article 217 says that while appointing the judges of High Court, the President will consult the Chief Justice of India, the governors of the state, and also the Chief Justice of the High Court. So Article 217, Article is 217. It is correct, it is correct, it is correct, it is not correct. So option is D. They must be a permanent resident of the state in which they are appointed. There is no such provision. Any person can be appointed, any citizen can be appointed as the judge of any high court in India, irrespective of the state or irrespective of his residence or settlement. Residence and settlement is not a qualification for the appointment of the judges of high courts. So that is D. Okay, that is D. 12 answer D. Good question. Question number 13. Look at question number 13. Which of the following is not correct regarding common high courts in India? Common high courts are established by the parliament only with the consent of the state consent. See, common high courts are established by parliament under an act. There is no requirement for the consultation with the state government in this regard. Okay, maybe the state government's request is there or state government needs it. So it is the sole authority of the parliament to establish a common high court. There is no requirement, formal requirement for consent with the consent, state consent. So statement 1 is incorrect. Parliament can extend the jurisdiction of a high court to a union territory. Yes, it can. It can extend the jurisdiction of a high court. The same article 230. The provisions are mentioned in article 231. Yes. Allahabad High Court is a common high court. No. There are 3 common high courts. Punjab, Haryana High Courts, Guwahati High Court and Bombay High Court. So Allahabad is not a common high court in India. It is the largest in terms of strength. So statement 2 is correct, 3 is correct. So only 2 are correct. B. Okay. Okay. That is the things. B. So only 2 statements are correct and the remaining 2 are incorrect. 14. The district judges are appointed by. The district judges are appointed by the President in consultation with the Chief Justice of the High Court. No. The Governor with the Chief Justice of India. No. The Governor in consultation with the High Court. C. This question is repeated. Okay. Who became the first Chief Justice of the Telangana High Court? Telangana High Court that came into as a restructured court in 2019, that we have already taken a question on that. So the first Chief Justice of Telangana High Court was totally B. Radhakrishnan. A. Question number 16. The pension of High Court judges are charged upon. The salaries and allowances and pension of the High Court judges are non-votable in nature. They are non-votable means the legislature cannot reduce the salary, allowances and pension of the High Court judges. They are not subject to vote in the legislature, whether in parliament or, okay. And they are also entitled to pension matching half of the salary last term. So that is a provision. So they are charged. But the thing is that the salaries and allowances are charged upon the consolidated fund of the state concerned, but the pension of the High Court judges are charged upon the consolidated fund of India. Okay, that is A. But remember, the salaries and allowances are charged on the consolidated fund of the state. Okay, difference is that. Okay, now come to question number 17. The salary and allowances of the Lokpal of India is equal to that of Chief Justice of India. Lokpal of India is a statutory office, is the highest anti-corruption authority in India, established under Lokpal and Lokayukta Act 2013. There were many initiatives, times the initiative was introduced or taken by the government of India since 1968. But the Lokpal bill could not be enacted due to differences among the political parties regarding its structure and power and functions. But finally it was passed by the UPA government in 2013 and came into force in January 2014. And the Act provides for establishment of Lokpal at the center and Lokayukta at the state level as a major and high-powered constitutional body, high-powered quasi-judicial body, and established under Lokpal and Lokayukta Act. The Lokpal consists of a chairperson who is known as Lokpal and 8 members, there are 4 judicial and 4 non-judicial. The salaries and allowances of the Lokpal is equal to that of the Chief Justice of India. But remember, a retired judge of Supreme Court is appointed as the Lokpal. Only a retired judge of Supreme Court can be appointed. So that is A. The Bombay High Court has benches at following cities except Bombay High Court has 3 benches. So there is Nagpur, Panaji and Aurangabad. Pune is the answer. Pune does not have. The answer is A. Who became the first Chief Justice of a High Court in India, woman Chief Justice throughout India? This is Leela Seth. Justice Leela Seth became the first woman to become a Chief Justice of a High Court. That is Himachal Pradesh. She served as Chief Justice of Himachal Pradesh. She is the first lady to serve as High Court Chief Justice. Geeta Mittal is the first woman Chief Justice of Jammu Kashmir High Court. He was recently appointed. And Fatima Bibi, Mira Fatima Bibi, is the first female judge of Supreme Court. Okay. That is the things. Now we'll come to question number 20. Who among the following is eligible for becoming chairperson of NHRC, National Human Rights Commission? National Human Rights Commission is a statutory body established under Protection of Human Rights Act 1993. It is a premier body at the national level to protect human rights from being violated. So it is a quasi-judicial body and has got certain power and functions. NHRC consists of a chairperson and 5 other members. Okay. Apart from that, there were also 7 ex officio members of NHRC. It is a very high level body located at the national. And the chairperson, the qualification of the chairperson was Chief Justice of India, former, but after 2019 the provision has been amended, and it is amended that not only the former Chief Justice of India but also a former judge of Supreme Court can be appointed as chairperson of NHRC. Today, Justice Arun Kumar Mishra is the chairperson, who was a judge of High Court, Supreme Court. B. 26, answer B. The National Judicial Appointment Commission was provided under. National Judicial Appointment Commission, or popularly known as NJSC, was established to do away with the collegium system prevalent in the judicial appointment. It had the ambition to do away with the collegium system where judicial domination is prominent in the appointment. The government of India wanted to dilute the collegium system and put in place a high-level body called National Judicial Appointment Commission for the appointment. National Judicial Appointment Commission was to be headed by the Prime Minister, and there will be 2 judges of Supreme Court, also the Chief Justice including, and 2 members from civil society, union law ministers. So it would have been a very high-level body, mixture of both executive and legislature. But the 99th Constitutional Amendment Act 2014 was declared ultra vires and null and void by the Supreme Court in 2015 in the 4th judge case. But the answer is A. Okay, but remember, 100th amendment is related to Land Boundary Agreement 2015, that is 14, and it is 2006. 93rd Constitutional Amendment Act provides for reservation for SC, ST and OBC in higher institutions of learning like IIT, AIMS, IIMs and other private sector recognized universities. So there is reservation for many communities. 93rd Constitutional Amendment Act. So answer will be A. Provided under. The National Judicial Appointment Commission was established by your National Judicial Appointment Commission Act D. There was a special act made in the past in the Parliament for appointment of NJSC in 2014. But remember, all these acts and the amendment, 99th amendments and National Judicial Appointment Commission Act 2014 have been declared null and void by the Supreme Court in 2015 in 4th judge case. 4th judge case. That is D. 23. The provision of appointment of district judges is provided under 233. What is the minimum age requirement for becoming the district judge? Remember, there is no age provided for the appointment of judges to district courts, high courts and Supreme Court even. No age is provided. So your answer will be D. Okay. So D, 23D, the first three high courts were set up in Calcutta, Bombay, Madras under Calcutta, Bombay, Madras High Courts Act 1860. No. Indian High Courts Act 1861. Yes. So the three courts, Calcutta, Bombay and Madras, were set up under Indian High Courts Act 1861, but they were set up in 1862. Calcutta is the first court to be established in India, and then Bombay, then Madras. So B. Odisha High Court was established on 26 July 1948. Odisha did not have a separate High Court before independence. It was under the Patna High Court, and before that it had been under Bengal High Court. In 1916 it came under the Patna High Court. It remained for a long time under Patna High Court until it became a separate court in 1948 on the recommendation of Justice Birokishore Rai Committee. The viability was accepted and established. So it is 26 July 1948. D. Consider the following high courts in India and state which one of the following option is correct chronological order of the years. Gujarat High Court was established in 1960. Manipur High Court is 2013. Himachal Pradesh is 1971. Odisha High Court is 1948. So correct chronological order will be 4, 1, 3, 2. 4, 1, 3, 2. Yes. Answer will be C. Consider the following statements. There are 25 high courts in India at present. There are 25 high courts, yes. Although we have 28 states and there are certain union territories who have their high courts like Jammu Kashmir and Delhi. So in total we have, you can say, there are 30 states. You can say 28 states and 2 union territories, but out of 28 states and 2 union territories, only 25 courts exist because there are other common high courts. For example, in Guwahati High Court, 4 states come under Guwahati High Court: Assam, Nagaland, Arunachal Pradesh, Mizoram. Earlier, Meghalaya was also there. It is separated, got a separated High Court in 2013. Punjab, Haryana and Union Territory have a common high court. Yes, it is correct. It is correct. National Capital Territory has its high courts of its own. Yes. So 1, 2, 3 will be the answer. Next question 29. Who was the Chief Justice of India when public interest litigation was introduced to the Indian judicial system? Public interest litigation or PIL is also known as social action legislation or social interest legislation, class action legislation. There are different names. PIL is an innovation in judicial process brought to India in 1980s. It dilutes the traditional mode of approaching the judiciary. It made it easy for a common man to approach the judiciary under PIL. But remember, PIL will only focus on public related cases, not personal cases. Okay? Then it was during 1980s, so P.N. Bhagwati, V.K. Krishna Iyer and many other prominent judges, a few other prominent judges, pioneered the introduction of public interest litigation in India. And remember, under public interest litigation, only public causes, the cases related to public cause would be entertained. No frivolous complaint, no frivolous PIL can be accepted. And the person who made frivolous comment or frivolous case, then he or she would invite contempt of court. So P.N. Bhagwati, the then Chief Justice of India, pioneered the introduction of PIL. V.K. Krishna Iyer. Okay, there are other judges also. The PIL is doing marvelous service to the people of India, and it is, for example, in 1976 in Khatun Hussain Hara versus Bihar case, the Supreme Court ordered to release the under trials who had served jail for more than 10 years, and by this 40,000 jail inmates or prisoners got released. Okay, that is the thing. P.N. Bhagwati. D. Consider the following statement. Justice V.K. Krishna Iyer was the Chief Justice of India. No, he was not Chief Justice, but he was a very prominent lawyer, prominent judge of Supreme Court. He is considered as one of the progenitors of public interest. Yes, that's correct. V.K. Krishna Iyer too. But he was not the Chief Justice of India. Okay. How many high courts in India have jurisdiction over more than one state? 3 high courts. Union territory is not included. If you consider union territories, then the number of high courts will increase. There are 3 high courts. Guwahati High Court was 4 states: Guwahati High Court and Bombay High Court, and their P and H High Court. But there are certain high courts like West Bengal. Calcutta High Court has jurisdiction over Port Andaman Nicobar. Calcutta High Court is not a common high court. Calcutta High Court has the definition of Andaman and Nicobar, but it is not a common high court. Like your Kerala High Court or Kerala High Court, it has jurisdiction over Lakshadweep, but that is not on there. So many cases are there. Okay, there is your answer will be 3. Okay. Three. 32. Consider the following statements. 2023 possible questions, previous year questions. The Supreme Court of India has held in some judgments that the reservation policies made under Article 16(4) of the Constitution of India would be limited by Article 335 for maintenance of efficiency of administration. There is a correct statement, 335. Although reservation is provided, but the efficiency in administrative sphere cannot be compromised in the name of reservation. Efficient people should be chosen. So that is the most fundamental thing of a governance. So that is there. That is the correct statement, 334. And Article 335 of the Constitution of India defines the term efficiency versus no. That is not mentioned in efficiency of administration. What constitutes efficiency of administration, that is left to the judiciary to interpret. So statement 1 is correct. Statement 1 is correct. Statement 2 is incorrect. Okay. So these are the questions on judiciary. I have collected about 70 to 80 questions we have already discussed on judiciary. That does not mean that no questions are left. Many questions might be left also, but we have discussed fundamental questions and important questions related to judiciary, those questions which are very prominently asked in different examinations. Basing upon that pattern, I have included very important questions to judiciary and judicial announcements. Kindly follow this, kindly go through the chapter well and learn basics of PIL, judicial review, judicial activism also deals with the cases that is a requirement for your mains examination, okay, and prelims too. So these are the questions we have already discussed. 30 questions. Next class we may continue this judiciary section if questions are found available. Otherwise we will start with your state government. We'll start with state government, but in governors and your chief ministers, all these things. Hope this class has been helpful to all of you. Watching this class will definitely give you a new idea about questions, and also we are discussing the questions and answers in a broad-based manner. We are not skipping the question by just pointing out the options. That is not the things. You need to understand the options. You need to understand the statements very well before getting on or deciding your answer. Don't be in a hurry. Always focus on the statements if they are given, because this is a most sensitive area where we require to act very cautiously. Okay? So in the next class, I shall be bringing you with different questions. If questions are left on judiciary, I will prepare that. Otherwise, we will start with governor. Okay? So there are some basic questions. There were some top level questions. There were some previous year questions asked in the different examination recently. Okay? So kindly follow, and any answer that contradicts your views or contradicts your opinion by your answer, then please write in the comment. Okay, I will work on that. So this is all about your class today, YouTube class. This is an initiative by the Vanik, a mega institution for coachings in civil, SSC and banking examination. It is doing a marvelous job, and it is a companion throughout your bad and good days. It will continue to remain with you until you achieve your goal. Trust us and follow us. Thank you very much for watching me and watching Vanik's YouTube class. Will come to meet in the next session. Thank you very much.